Yes, my peeps, night time. Welcome back to the channel, Yardman Second Chance channel. We'll big up Father God. I don't know we do it over here, say no. Father God come first in all things. I give thanks to Father God for preservation of life. And big up all my subscribers. Well, today, the DPP are the subject, And we see she got called the ruling drop today and say it's unconstitutional. She have to exit the office. So, you, Wildman, who is a King's Counsel, constitutional lawyer, I explained to Andre and Isat Buckanan what really go on in the case, not the ruling what go on today. So I could listen and hear what really go on. Take it away.
Mr. Wildman.
Good night, you hear me?
Greetings, Mr. Wildman.
Greetings to you too.
You, Wildman, what is happening in Jamaica as we speak?
Boy, a lot of things seem to be happening, including the latest one today.
The latest one today. Didn't you carry a claim against the present DPP?
That's correct. And in fact, there's one in the Court of Appeal and there's one in relation to this amendment, and was on the list to be heard last week, but the judges were not available. The matter was rescheduled. And the same points which were taken today in this matter, those points are also taken by me in my claim.
So the claims that Mr. Hilton made in front of the court are the same claims that you made.
That's correct. That's correct.
Right?
In my claim, my 6-day claim form, and that.
So can you tell us some of those claims that were made? Come and tell us what the claim.
I mean?
Can you re-echo the claims that were made in the claim?
Okay. What essentially my claim is, and which is also what came out today, is that we are saying that the amendment to the Constitution that the government effected to give the DPP an extension, so to speak, the continuing office, could not apply to the present DPP. Because the DPP was already appointed pursuant to Section 96 of the Constitution, and under that constitutional provision could not go beyond a certain age, which is 60. Yes.
What is the age? 60?
60, and then it permits for one further extension, one and only one extension, which she got. Therefore, she would not be eligible for a second extension. And so what in effect the amendment seeks to do was to give a second extension. Arose by any other things arose. And so what they did was to trying to bypass the strictures under the Constitution governing the appointment or extension of the office of the DPP. And the point I was making, I made in my claim, is that the amendment could not have a retroactive effect. It is prospective and not retroactive.
Explain the retroactive to the viewers tonight.
Okay.
You're saying that it couldn't be done with the years already passed.
That is correct, because she already served her tenure under the old Constitution provision. So you can't revive it. You can't rewrite history. That's what the amendment seeks to do. By making it retroactive, seeking to make it retroactive. Like you want to rewrite history, which you could not do under the Constitution. And that is where they were caught. So I'm not surprised of the ruling today.
So that was part of the ruling.
Yes.
What else can we bring in the next renowned attorney on the screen, please?
Yes.
So there are 2 attorneys. I'm just the makeshift one tonight.
Yeah.
I am the judge and juror over here tonight.
Yes.
I am the judge and the juror. I remembered when you carried the claim.
Yes.
Isat was on the program and he further extended that granting that second extension
Yes.
was unconstitutional.
That's correct.
Why is the Minister of Justice so hell-bent to say that in going to ask for and in carrying it to the appeal? I want to ask, can this be carried to the appeal with what the judge said today?
Yeah, let me explain.
Yes.
Yes, it can be appealed, but you cannot get a stay because you cannot get a stay of a declaratory judgment, which is what this is.
A declaratory judgment. Explain to the viewers tonight.
Yes.
What is a declaratory judgment?
Declaratory judgment. A declaratory judgment is where you ask the court to pronounce on the legality of something. Okay? And the court says, based on what is before us, the facts, the evidence, the law, this action is illegal, unconstitutional. That is a declaration. That's a declaration.
Basically going by the books.
Yes. So what the court is saying, as between the parties, what is before me is unconstitutional. A declaration. So you say you're not making an order. You're saying that, and you see, and there's a reason for this in that
yes.
When you have challenges of this nature, it is normally expected that when the court makes a pronouncement that something is unlawful, the parties will respect it because it is a pronouncement by the court, the Supreme Court. So the Supreme Court makes a declaration that something is unconstitutional, the parties will abide by that ruling, and that what the late Chief Justice of Trinidad and Tobago, Sir Hugh,
yes.
He speaks of what he calls a binding declaration given by a court. It is expected that when the court makes a pronouncement, the parties will respect it. So today, when the court makes the binding declaration, it is expected that the Attorney General's chambers will respect it, yes. And to ensure that Ms. Llewellyn should have vacated office immediately today. She should not be seen in the office of the DPP. She should have left. And
so, that is yes. What you're saying, that from the declaration was made today,
yes,
in the court,
yes,
basically the DPP office is on a lockdown.
It's vacant. The office of DPP is vacant.
Isat Buckanan, let us get your interpretation.
I agree with everything Senior Counsel said. There is not much to add. When one reads the judgment, I think it is clear because the judges were very careful to set out what the reasons were. If it needs more clarity, this is where persons would say law students, at a minimum, law students could at least appreciate what was done by the judges. And the judges were careful. There are questions about retroactive application that is clarified that certainly if it is that the Parliament is free to amend the Constitution to raise the age, it certainly wouldn't benefit someone who is acting on an already extension which has expired. So by essence,
for the Parliament,
yes.
Just for clarity,
mm-hmm.
What the judge is saying, the Parliament can increase the age for the DPP, right?
That's correct. They're not taking any issue with that, and
yes.
I would go as far as to say nobody ought to take issue with that because that is it's reasonable for lawmakers to find that the Constitution is an evolving document as well. It has to serve people in that we are living longer, we are health-wise, we are doing many things. Society has changed. what it doesn't do is when laws are made, the retroactive application has to be something that is clearly spelled out, the effect of it. And so what it would have done, what we have to appreciate is that while when granted an extension,
Yes.
and that was something that was challenged by Mr. Wildman initially about
Yes.
that extension. What was even clear from that challenge is that the office holder was holding office by extension.
That's correct.
So you had already passed the age of being the office holder.
That's correct.
Granted a mechanism within the Constitution that allows you to hold the office.
Yes.
So you are actually the office holder by extension. When
That's correct.
extension expires, you can't say that I am the office holder because you're doing so by extension.
So for clarity,
Mm-hmm.
her first extension
Mm-hmm.
done.
Yes.
Yes, we are actually beyond that.
Yes.
Yes.
So if this first extension done,
Mm-hmm.
them rush, you just go through the procedure. Something was rushed in the
Yes.
parliament to extend the age, right?
Yes.
When that happened, it at the time, it did done pass. The age period just done pass.
That's correct. Yes.
Now make it unconstitutional.
Yes. Yes.
Yes.
So with that unconstitutionality, a future DPP can get it, but she can't get it.
That's correct. And that's the point. That's the point. That's the point I made in my.
We want everybody to understand.
Yes. In other words, the amendment could not apply to an existing holder of the office of DPP. It applies to, it is prospective, not retroactive. And the point that I think is causing some confusion from the judgment, because I listened to the delivery of the judgment. I'm not ready to it, but I listened to what was said. And the key point is this. And this is where I think the AG's office and Mr. Chuck are on the wrong track. Listen to this.
Can you give them some? I want to.
Yeah. Let me explain. In every judgment delivered by a court,
Yes.
you have what you call, the judges will make comments, what you call obiter dicta or obiter dictum. Dicta is the plural, dictum is the singular.
Repeat.
So they will make
and
obiter dictum.
Yes.
So what it means is that by the way, the judges will make statement on law, comment, but it is not, those obiter dicta is not the ratio decidendi of the case.
It's not the what? The
ratio decidendi.
Lord, we are learning over here tonight. Students, write it down, you know. So
The ratio decidendi. The ratio decidendi is the actual decision of the court.
Yes.
On the particular point which they are called upon to make a determination. So in this case, the ratio decidendi of the judgment is that the amendment does not apply to the incumbent, and so she could not have benefited from it to get an extension. So her appointment is unconstitutional. That is it, in a summary, is the ratio decidendi of the case. So everything else said in the judgment, you call that the obiter dicta.
Yes.
So what Mr. Chuck they are trying to do is to latch onto the obiter dicta and ignoring the ratio decidendi of the case.
Oh, so them take the judge writings.
Yes.
And want to use the judge writings.
That is correct. That is.
Oh.
So they're missing the ratio decidendi of the case.
Well, what actually when you read the case,
yes.
I know you read it, Isat. You know.
I know, but I'm just saying when one reads the case, if you're stuck on paragraph 1,
yes,
and you don't pay attention to the
yes,
81, when you read them together, you get
yes,
that there are two sections. The section, if it's 2A, 2B, what something.
Yes.
Yes.
The actual section which speaks about the office holder having the option or a right to write a letter of extension.
Yes.
That is the part that was struck down, and that is the significant part that would say
that is it.
you can stay in office to 65 if you so desire.
That is correct.
What the court has said in their the rationale of the court is
Yes.
in their decision is to say, listen, you notwithstanding you cannot legislate outside of what the Constitution already is, which is consultation, albeit that the court said agreement, but consultation between the leader of opposition and
so,
the Prime
just to make it clear, Isat, there, sir.
Mm-hmm.
The court is saying the only way at this time would be granted the extension is if Andrew Holness and Mark Golding come to an agreement, right?
But the problem there is that could not be done because she was already given a first extension, and the Constitution prohibits a second one. That's the key point.
We are to be having conversations about what is the effect of a declaration that makes a section of the Constitution void. What is void is as if it never happened.
That is it.
We are now having a conversation about something that doesn't exist.
Yes.
So I understand it now that the court, which is the custos morum of the Constitution, the guardian of the Constitution, there can have some discomfort come Monday morning to give audience to somebody that does not exist. This is about goal now.
In fact, I took that point today in court in arbitrary because when just after the ruling, I was on my way to court in arbitrary, and a new matter was to commence, and I indicated to the judge and the clerk of court that in light of the ruling that just occurred, they would have no basis to commence a prosecution because under the new system, the trials are now done on behalf of the DPP in the parish court. So the DPP office being vacant, the clerk would have no jurisdiction to commence a prosecution in these courts. And they are to adjourn the case.
Yes.
They are to adjourn the case.
Are you saying tonight, with the ruling that happened today, right across Jamaica, every court have to now be on a standstill?
Every criminal court.
The criminal court. Because the DPP, who the prosecutors represent.
That's correct.
Oh?
Does not exist.
The office is vacant.
Office is vacant.
Oh, nothing can keep now.
Nothing can keep.
Nothing. Rightfully, the effect of what happened today is that the office is vacant and needed immediately. So
that is correct.
Morning, this is the beauty of you won't see the doctrine of separation of powers in the institution. But that's the beauty of it, because the judicial arm is going to say we can't give you audience because
that's correct.
It exists. And what is going on
I want to go further with you now. So seeing that the office is vacant.
Yes.
That is one.
Mm-hmm.
I hear the Justice Minister saying that he's going to apply for an extension of stay.
Let me explain that. Again, the Justice Minister is going on the wrong route. You cannot get a stay of a declaratory judgment.
You hear there?
Because
you hear there? Listen again.
You cannot get a stay.
Get a stay. You can't do more work.
Of a declaratory judgment. Okay? And in fact, if you will recall, when I took the case against the JPS years ago, and Justice Sykes as he was then, he was the one who heard the application, and interestingly, Mr. Hilton was my opponent in that case.
Interesting.
When I challenged the legality of the JPS license, and Justice Sykes agreed with me and granted a declaration that the license was invalid.
Oh.
And there was a big talk in the country as to whether they could get a stay pending appeal. And they recommended that they could not get a stay there to back up until they appeal the matter. So the point I'm making is that that was an example where a declaration was granted by the Supreme Court, and they could not get a stay of the order of the declaration until they appealed. So I am saying to you that the Justice Minister is totally off track here when he says that they could try to get a stay. You can't get a stay. But what can be done? What can be done right now? If the DPP insists on going into office Monday morning, if the other side, the claimants, can see that
is Philip Caldwell and Peter Bunting.
Yes, they can seek an injunction immediately to restrain her from entering that building.
So you're saying Philip Caldwell and Peter Bunting need to get the services of Mr. Hilton, King's Court.
Yes.
So that Mr. Hilton can get an injunction. So she
that is correct. That is correct.
I can take it one step further and say the criminal lawyers who wake up Monday morning and don't feel like they want to and get an injunction to say.
That is correct, because that's the point I was making, that if a lawyer goes to court, and my colleague is there saying, Mr. Buckanan, if a lawyer goes to the criminal court Monday morning, and hears that the DPP is still there and prosecutors acting on her behalf, they can seek an injunction.
Oh, really?
Yes.
So you, Isat, can seek an injunction? Why? Sir Isat,
No.
just for clarity, you, with the case when we come up the 13th,
Yes.
you can seek an injunction against her?
That's correct. That's correct.
Except the approach that I would take against who? That which doesn't exist, you can't get into a battle.
No, you can't get an injunction against the Attorney General. Wait. You can't get an injunction against the Attorney General. Because remember, in this case,
Mr. Wildman, students, we're here on Padlet Raw TV, learning about the beautiful nature of the law. And the beautiful nature of the law is being explained by Mr. Hugh Wildman and Isat Buckanan.
Yeah.
I just have to pause because we're at that part now. We're going to go into the Attorney General. Come now.
Yeah, so what I'm saying is that in this case, the parties to the proceeding are really Mr. Paulwell, Mr. Bunting against the Attorney General. Mr. Llewellyn is not named in the claim.
Oh,
Mr. Llewellyn, anytime you file a constitutional motion under the Constitution of Jamaica, the AG represents the state. So in this case,
that is the people's attorney.
That is correct. So in this case, the proper party representing the state will be the Attorney General. So Ms. Llewellyn is not named as a respondent or a defendant. So if you were to get an injunction Monday morning, it will be an injunction against the Attorney General to prevent the AG from having Ms. Llewellyn continuing in office as DPP. That's what it is.
Right. That's accurate, but that is why so this is a matter of style, because one simply needs to also appreciate that you can, as Mr. Wildman did this morning and other lawyers would have done, is to say, why are we here? And
that's correct.
There are judges, most erudite judges in our court system that they respect for the Constitution. And that's what you must understand. This is about the Constitution. It's about the rule of law.
That's correct.
Not a personal attack on the office holder. It's about the procedure that must be respected.
That's correct. That's correct. And that's the point I took. That's the point I took this morning. That I explained to the judge is a constitutional point, and she had to set a new date for the case.
So where do we go from here?
Well, as I say, I think good sense should prevail Monday morning. And I hear some arguments about appointing an acting DPP. That is not correct. The Constitution does not make provision for an acting DPP.
Right.
So you can't. the Constitution does not make provision for acting DPP. You can only make a full appointment as DPP. So right now, no one in the DPP's office right now can sign a paper right now. Nobody can sign a paper because there's no DPP in place. So none of the deputies or senior deputies can sign any paper down there. You'll be getting in trouble.
No. So you're telling me that the entire government jurisdictional process is on a standstill?
That's correct. Because no deputy can sign when there's no DPP in place. You see, the concept of the deputy DPP or the senior deputy is not known to the Constitution. That is an administrative concept.
That came about. So the deputy is not in the Constitution.
No.
But to be fair, the Constitution makes provisions. That's why it makes provisions for somebody to act on.
But you can only act when there's a sitting holder of the office.
I know, but if the sitting holder for any reason.
It doesn't exist. It doesn't exist.
There is no
holder. Not there.
Where is it?
Not there.
If the office becomes vacant, I can tell you now because it's 96.
Yes.
It says when it becomes vacant as it is now.
Yes.
As it is now, there's some whoever is qualified. I could give you some names, like it's fine. If these persons, for instance, they are qualified, they have
and Jeremy Taylor.
Did I say this pipe?
But Isat, the point I'm making, Isat, is that if there is no DPP, just like for example, let me give you an example.
Yes,
the concept.
I love this program tonight.
The concept of the DPP and its appointment follows the concept of the Chief Justice. You remember when Justice Sykes was appointed as acting Chief Justice? He couldn't, you know why they had to quickly appoint him? Because people like me made the point that there was no scope for an acting Chief Justice. That's why they had to quickly go for the Chief Justice and appoint a Chief Justice.
I had retired.
That is correct. So it's the same thing here. It's the same thing here.
Section 96.3 is a little bit different. Let me just read it for purpose. If the Office of Director of Public Prosecutions is vacant, as it is now, or the whole of that office is for any reason unable to perform the functions thereof, a person qualified for appointment to that office is appointed to act therein, and any person so appointed shall, subject to the provisions of subsection 1 of this section, continue to act until the Office of Director of Public Prosecutions is filled. Is filled, or as the case may be, until the Director of Public Prosecution has resumed the functions of his or her office. Of that person, by the Governor General are acting. The section 96.3. The steps that have to be taken, I'm humbly suggesting, would be, rather than going into a losing battle, repeating, because insanity is over and over. The government has now gone into a track record where when they don't like the rulings, it's a sign of disrespect to the court to challenge something that you know you're not going to challenge, i.e. the Everton Douglas matter. They did a whole appeal and there was no legal basis to do it. So if somebody asks me, can they appeal? Yeah, you can appeal anything. All you're going to do is beware, you're racking up costs. And with the ilk of lawyers that are on this particular thing, we're going to be spending millions of dollars to pay costs for an appeal that they are going to lose. It's a simple, but let me read that 96 for you. That is where we're at, and that's a conversation we have to have, is that the government has nothing to lose. The people, we have something to lose, because we are going to pay the lawyers, we are going to pay the claimants' attorneys for expedition.
Just let me rephrase for the thousands watching in layman terms. If them plan to go to appeal, we Jamaican people have to go pay for the lawyer them for the appeal, right, Tara? That's what you're saying?
Yes,
That's correct.
But that not right to we poor people when the Supreme Court don't deal with that already.
Well, that's a policy decision that the government will have to make. But the point is this, you know, is that the Constitution, the language of the Constitution, is that it contemplates that there's a hold of the office of the DPP.
yes, yes.
For example, when the DPP is, like say the DPP is off on vacation, you appoint somebody to act. That is permissible.
Because she's in the office.
That is correct. Okay?
But there is a clear vacancy.
But where there's a clear vacancy, what should be done, as was the case of the Chief Justice, is that the person must be appointed as DPP. Now, that the DPP is sick, you know. If the DPP is sick, then clearly somebody can be appointed to act. But we are court, because you go back to that section of the Constitution which says,
Yes.
and it's another area of debate, whether what the DPP has done over time that she was there.
Oh,
Can
yes.
be-
I want
can be-
to get to that.
Yes. Everything is tied up here.
I saw another attorney. What name?
Yes.
It's Christopher Townsend.
Yes.
Questioning from the time she got the second extension
Yes.
to present. If the
Yes.
cases that she ruled over during that time,
Yes.
they were constitutional.
That's the point I'm making. That's the point I'm making. And that's another area of debate, because it is my position that everything that she would have done since this amendment and extension would be a nullity.
Oh,
That is, it will void. And the reason for that reasoning comes from the Paul Chen Young case.
what is the Paul Chen Young case?
That's a case where a judge, the judge of the Court of Appeal, had sat and gave judgment
Yes.
after they had retired.
Oh,
After they had retired. And the question is whether the judgment that they gave was constitutional, legal. And the court,
so you're saying the Paul Chen Young case where the retired judge gave the judgment.
yes,
They question whether or not the judgment had any effect.
that is correct, and it was held to be void.
Oh. So,
It was held to be
so wait, let me say, well, nah, Jesus. No. Me just want Jamaica know.
No,
So, yeah,
you're gonna have your students curse me because you are making me laugh, and it's not.
No, I said, we have to ask. We just want for sure say the bangarang a bangarang. So yeah, say Mr. Wildman and Mr. Buckanan.
yes,
From last year September
yes,
to now,
yes,
all of them the ruling where she did make
yes.
are questionable.
That is correct. In fact, that is part of my claim too. Yes, that's part of that, and that's the effect of the ruling today. That when something is declared to be void, in law, it is said to have never happened. This void ab initio, that's called a Latin concept.
No.
Void ab initio. That is to say, it never occurred. It never occurred.
Agreed.
Jesus. But a serious case them there, you know.
That's correct.
But Mount did make the talk, I said. Why?
You know, I will say this though, Mr. Wildman, I am so happy that you're here because
Yes.
I would wonder, I would have sought your guidance on this in any
Yes.
Section 96.2, and
Yes.
I have been grappling with this.
Yes.
I share your view on the void ab initio. That's
Yes.
how I understand it. That's the school of
And listen to the reasoning of that section now.
yeah.
And this is very important. This is very important.
This
Very important.
and grapple.
That section 96 too. Let's listen to the reason of this now.
Section 96 too.
Yeah,
Yes.
but this is what causes the debate now on whether
Yes.
this is so. It says
You can read it out for me, Isat.
I'm
Yes,
going-
yes.
nothing done by the Director of Public Prosecution shall be invalid by reason
Yes.
only that he has attained or she has attained the age at which she is required by this section to vacate her office.
That's correct.
The question
And that section
No.
has been judicially considered. Judicially considered.
Yes.
And the effect of that is this. Where the office holder was put on notice that the challenge is going to take place,
Yes.
and the office holder insists on remaining in office, then the section cannot avail you. So in this case, the government would have been put on notice that if Ms. Llewellyn's appointment is declared to be void, then whatever she does cannot be saved.
It cannot
They would have been put on notice.
So you're
That is
saying she didn't get the notice already, so anything
That's
she
correct.
do from then to now,
That is correct.
this is
And it simply means also, that the course to be taken now is to ensure that someone, as Mr. Wildman says, is immediately put into the office
Yes. Yes.
in the interest of justice.
That's correct.
That somebody could act. I would yield to senior counsel, but in any event, it would appear to save the integrity of the office.
Yes.
As to be at the wheel.
So
Otherwise, we'll be going in the territory where.
And you know why the acting thing is dangerous. Let me tell you why the acting thing is dangerous. I was involved in a case in Grenada.
Yes.
Where a similar situation occurred, where the Malcolm Holdit case, where he was put on contract, which is like an acting, and the court, Eastern Caribbean Court of Appeal, declared that the appointment was void. Because when you put a DPP on contract, they say you made the DPP beholden to the executive.
Oh,
that case, I have that case. Okay? The judgment was delivered by former head of the CCJ, Sir Dennis Byron, to put the DPP on contract or acting would amount to be tantamount to.
So you say if she's even on a contract, it would have
Yes. It would be wrong.
So that means, I want to ask another question. Just being, so all of them, they raise a pay what she get from last year to now. She not have to return it.
One.
Let us answer that. Well, I would not agree that she has to pay back that. You know why? Because that is between she and the government. So she can sue the government, say you put me in a job and I work here to pay me. So there are two separate issues. But for the purpose of the appointment itself, that the appointment will be void. But she can say to the government, you put me there, you have to pay me, I work. So there are two separate issues.
And she would be right, respectfully.
That's correct. So two separate issues.
She has actually done the work.
That is correct. So she can say you have to pay me. So she can't be compelled to return any money.
Right.
But what is clear is that she can't continue.
Yeah. Wow. So she can't continue. Can
No.
we play the video of Elroy Chuck talking tonight? And then
Yes.
play the video of Elroy Chuck, producer, please, and thank you.
Justice Minister Delroy Chuck says come next week, the government will be filing documents to appeal the ruling handed down by the Constitutional Court.
We do not agree with that part of the ruling. Position is that we intend to appeal early next week, so the matter will remain until the Court of Appeal rules.
The ruling means that Director of Public Prosecution Paula Llewellyn's appointment is null and void. When our news team visited the minister, the 58-page ruling was spread across his desk. He admitted to not fully reading the document as yet, but believed the government has a solid case. Minister Chuck rubbished the argument that the DPP received a second extension in her tenure. The DPP should have demitted office when she turned 60. However, she was granted an extension in 2020. That ended last year. The minister explained that when the government passed the amendment, it gave her the opportunity to work up to age 65.
This is a new act to replace the existing provisions in the Constitution. It stands on its own. And in those circumstances, the DPP applied to continue to age 65 under this amended Constitution and has nothing to do with any additional extension.
Justice Minister Delroy Chuck says despite the ruling this morning, the amendment to the legislation was not rushed. The government would have passed the legislation last year using its majority in both the lower and the upper house. The opposition, on the other hand, said it was not consulted.
There's no doubt that we try to consult the opposition as much as possible, but there comes a point after you consult, you must make a decision. I think the opposition tries to milk as much political capital out of it, which I think is totally unnecessary.
So you don't think this amendment was rushed in any way?
It's a simple amendment.
It's critical, though.
It's a simple amendment raising the age from 60 to 65, which should have been done 10 years ago. And I don't think that was rushed.
As it relates to what happens now, well, the minister says it will be business as usual, but there are concerns about the impact the ruling could have on several high-profile cases currently before the court. We asked the minister, should the public be worried?
No, not at all. As I say, the status quo remains, and until the Court of Appeal rules, I don't think we have to act differently.
Jamila Maitland, TVJ News.
Gentlemen, her boss is saying she can't go back and work more.
No, let me respond to a couple of things there. In fact, Mr. Chuck defeated his own argument. One, you heard he said, continue. The amendment makes her able to continue. That defeats his case. Because that's exactly the point we are making, which I have made in my claim and which also came out in this judgment. It means he's conceding that Ms. Llewellyn's appointment emanated not from the amendment, but from the old provision. He's making that concession.
Oh.
So let me repeat. He's conceding in that statement when he say it allows her to continue, that her appointment ab initio emanates not from the amendment, but from the old 96-1. Having made that concession, it means that the strictures of 96-1 apply.
Yes.
That old 96. And secondly, it means that the new amendment cannot have retroactive effect to supersede the old 96-1. So he has defeated his own argument in that claim. Secondly,
yes.
Or thirdly, he can't do business as usual, as he says, for the following reason. You can't get a stay and an appeal does not operate as a stay. So you can't do business as usual. It means that he's in a dilemma there. You have a vacancy to be filled by virtue of that ruling, and so what he should be doing now to protect the integrity of the Constitution and the integrity of the criminal justice system, to have an immediate appointment to the office of DPP.
Should he be spending more time focusing on getting a new DPP?
That is what should be done today. That is what should be done today. That is correct. That is correct. So it can't be business as usual as he's advocating there. It will not be, because when you go to court Monday morning and all the judges say, come, say, I will not hear you. as was said today. In fact, I heard that.
In St. Anne, the
No, but I heard that in the home circuit court today. After the ruling, the DPP went to a court and the judge told us I can't hear you because who are you?
What you said?
Yes, I heard that today.
What you said, Mr. Wildman?
That the DPP went to a judge in the Supreme Court today and the judge said, who are you? And she said, the DPP judge said, no, I can't hear you.
What? Bangarang. So that happened in the circuit court today?
Today.
That's the state across the country.
Yes.
And that put up breaking news. Breaking news producer. She going at the Lord Jesus. So she going at the court.
Yes.
And she go do case.
Yes.
And the judge look on her.
I said, who are you?
You hear that Jamaica is only on Partner Draw TV you get these exclusives. She went in.
Well, peeps, we hear all what you Wildman say. So, we just have to just sit back and see what will be the outcome. Saying, so, them have to go try find a new DPP right now. That are the best bet. Government say them are going to appeal it. So, you know, so it's a bangarang. Right now, we're not saying nothing about cartel yet, you know, because that's a different show. We just have to try to figure out now what will go on with Paula Lewin and the government and see what will go on with her position if she will vacate the office and might get a new DPP. So we're going to sit back and watch what will go on. We'll bring on a further update as the drama continue. Saying, so keep on watching my channel, you know, Yardman Second Chance. And tell a friend if you tell a friend. And remember to watch the ads. Don't skip the ads. Saying, Yardman Second Chance. We out.